Let's turn to a particular form of employment discrimination, harassment. As I said, for lawyers, I consider this the Cliff Notes review of the law. For non-lawyers, here's hopefully a non-legalese description of the legal rights. So first, this is also sort of the highlights from the FAQs. I know those are, the link to that is in the chat. So it's really the highlights of it. So first, what is illegal harassment? So it's not just a person being a jerk. I mean, jerky behavior is bad. Respectful workplaces training can help stop uncivil jerky behavior. But for legal purposes, it has to be unwelcome jerky behavior based on a protected characteristic. And as I just explained, both sexual orientation and gender identity are protected characteristics under federal employment civil rights law. Now, this unwelcome behavior based on a particular characteristic can be directed at a person with that characteristic. Okay, so now we're going to be focusing on LGBTQ plus individuals. So it could be making jokes about the fact that the person is trans or gay or lesbian or bisexual or queer, right? It can be mocking a particular person on that basis. It can mean touching that person in an unwelcome, uncomfortable manner. For trans folks, it can mean not letting that person use a bathroom consistent with their gender identity. Or it can mean deliberately and consistently misgendering the person. Okay, these are ones not that the Supreme Court has held to be covered harassment, but other courts in the EEOC have these last two examples. But these are all unwelcome actions directed against a specific person. The unwelcome bad behavior can also be directed against LGBTQ plus people in general, right? Because that general bad behavior can have a negative impact on an individual LGBTQ plus person in the workplace. So negative comments or jokes or slurs against trans people in general, or gay, lesbian, queer people in general, can also be illegal harassment. Now, this unwelcome behavior can take place inside a workplace. It can take place in a physical workspace or a virtual workspace. It can take place outside the workplace, right? It can take place in a social setting where you're sitting around with coworkers. It can take place at an employer-sponsored event with non-employees at that event. Okay, all of these locations and forms of interaction are covered. Harassment can come from a boss, from a coworker, or from a subordinate. It can come from a third party, right? A customer, a vendor, or someone attending the employer-sponsored event. Now, what makes this bad, unwelcome behavior illegal harassment? Under federal law, the unwelcome behavior based on that characteristic has to be either severe or it has to be pervasive. Now, the courts decide in each case whether something is severe or pervasive, but you can get a sense of what it means just by thinking about the plain language, the plain meaning of the words. So severe behavior will be something like touching someone in a sexual manner without that person's consent. Okay, that behavior does not have to happen more than once to be considered illegal harassment. Pervasive behavior is behavior that is happening on a frequent and constant basis. So mocking a transgender person once is not going to meet that standard in court. But mocking a transgender person or making nasty jokes about transgender people in general on an ongoing, consistent basis, that would rise to the level of being pervasive and hence illegal harassment. I mean, basically, another way in which it's described is a reasonable person would have to experience that behavior as hostile or abusive, right? And if it's pervasive, that would be the case. And the person who's the target has to also have experienced the behavior is hostile or abusive. So it's both a subjective and an objective piece. Now, let me be clear. Good employers have policies that prohibit any of this type of behavior, even if it happens only once. Right? Every policy that I write for an employer has in bold, the goal is to nip bad behavior in the bud before it becomes illegal. And to be honest, in trainings at employers who have these policies, I hardly even ever talk about what is illegal, because the point in the training is to say you can't even do this once for that employer's policy. But for here, because what we want to talk about is what is going to be illegal harassment and how is the EEOC going to be dealing with these, I wanted to add the legal definition, although hopefully in a way that's easy for non-lawyers to understand. Okay, so that's what is illegal harassment. The second area covered in the FAQs is to talk about what to do just as a practical matter if you experience harassment. So I have three sort of highlights here on that. First, and these are all in answers to both questions 10 and 11. First, document what is happening. Okay, start a written log of what is happening with dates and descriptions. Download or photograph offensive text messages, emails, or social media posts. And, fortunate to have to say this, but keep copies of those notes on your private device or computer or at your home, and not only on your work computer. Like, you might have it on your work computer, and that's fine in terms of you're informing your employer, you want to forward some email you got or a text message, but also have it on your private device or computer. Second, you will need evidence that the unwelcome behavior is happening because of your protected characteristic, right? Because of your sexual orientation or gender identity. Sometimes that will be obvious from the behavior, but sometimes it won't be. And in those situations, you need to have evidence the person knew about your sexual orientation or gender identity. And these are the reasons why they were acting in the way that they were. The unwelcome, jerky behavior based on your protected characteristic. Third, you should report the harassment to your employer. Now, I get that that's not easy if you are afraid about retaliation. And again, good employers spend energy making it clear that it's safe to report. But hopefully, you're at an employer where that's the case, and it is important to report the harassment if you feel capable of doing so. Now, you can report to your own supervisor, assuming that's not the person harassing you. You can report it to any supervisor, because that supervisor will then have a responsibility to make sure the information goes up the chain. And, I mean, most employers have a policy against harassment. They have figured out to do that, at least. And that policy should say you can report to your supervisor or to any other supervisor, and then it'll direct you to some, perhaps a person that's been designated to get these reports. Sort of depends on how big the employer is. And here's the thing, you don't need to make your report in writing, but it is helpful to do that so you have a record of your report. Now, once an employer learns about the behavior that you are complaining about, regardless of who you reported it to, the employer has an obligation to investigate your complaint, to determine if harassment has occurred, and to stop the harassment. These obligations on the employer are triggered by you notifying the employer in some way. Your supervisor, any supervisor, the HR, those obligations are triggered once you notify the employer about the harassment. Now, the employer has a pre-existing obligation not to have harassment. The employer is not protected if you just go to the EEOC and didn't report to the employer, okay? But an employer suffers greater monetary damages if you report and they don't do anything about it. Now, like I said, obviously, an employer needs to create an environment in which you feel safe reporting the harassment, right? Because if that's not the environment, people fear retaliation. Now, if you're retaliated against for reporting harassment or helping someone else report harassment, that is a separate legal offense by the employer. And in fact, it was very clear at the EEOC where we got the most number of charges were retaliation charges. It was often easier to prove retaliation than it was sometimes to prove the underlying harassment. But it's no fun. So, best situation is where you feel safe reporting because you feel confident your employer will do something about it and protect you from retaliation. But if you don't get relief from your employer, that's when you may need to turn to outside legal relief, and that's where the EEOC now comes into play. Or if not the EEOC, then some state or local comparable agency.